case number 4 this morning is Dysart versus Circle J, and you will have 15 minutes, and the other side will have 15 minutes, and you may reserve the top.
Thank you, Your Honor. I will reserve the 5 minutes. May it please the Court, my name is Carol Williams. I represent the appellants in this matter, Jamie Snyder, Jody Snyder, and Circle J LLC. This case involves the purchase of real property subject to a purported easement for the use of a driveway for the benefit of the appellees. The appellees sought in the trial court and were granted reformation of the document at issue in this case, changing the language from this agreement may be terminated by the grantors or the grantees to this agreement may be terminated by the grantors and the grantees. The parties dispute whether the relevant document was an easement or actually granted a license. Irrespective of that, reformation was improper because there was no evidence before the trial court that there was a mutual mistake between the original parties to the document, the Mosques, who are not parties to this appeal, and the Dysarts, the appellees. To have a mutual mistake, the parties to the agreement must have made a common mistake or the same mistake. All parties to the agreement must have understood that the document was intended to say the same thing, intended to say what the party seeking reformation claims it was intended to say. In other words, but for the mistake, the document would have said what the proponent intended for it to say.
Which would actually go along with the idea of the easement, obviously.
Arguably, based on the testimony,
Their document itself calls it an easement and recorded, right?
the document does call it an easement. The label of the document is certainly less important than the contents of the document and the description of the rights and obligations under the document. And here the document did say grantors or grantees.
But it also says runs with the land, calls it an easement, and it's recorded.
It is. I think within those characteristics, the only one that really supports the conclusion that it was an easement is that it runs with the land. That is certainly more typical of easements. It is possible for a license to run with the land. Generally, that's considered I can't think of the term offhand, I apologize, but it is a license coupled with an interest. The other characteristics that you described, the fact that it is recorded, is not in and of itself evidence that it is an easement. Certainly easements are recorded more often, but the purpose of recording the document is simply to put third parties on notice. It does not actually have a legal implication for the contents of the document itself. It is not prohibited for a license to be recorded either. The other issue, as far as the contents of the document, is that it does provide certain situations in which it may be revoked. Those situations were not exclusive. The document does not say revocation is limited to these certain situations, and there is no indication that it was not actually intended within the terms of the document itself to allow unilateral revocation by one of the parties. The fact is,
And do you need all those situations to get the unilateral revocation?
you wouldn't need it, certainly.
Like superfluous, then what's the point of even bargaining for that?
Well, it's helpful, certainly, to the parties to understand what the expectations are for the use of that property. In this particular situation, it is limited, the right to revoke is authorized if the Dysarts, the owners of I guess it would be the dominant estate, were to divide the property up amongst future buyers, essentially transfer individual parcels of that land, essentially indicating the expectation of the parties to the original agreement that it was to be used only for the benefit of the home on the property, as opposed to allowing them to create, for example, a subdivision with numerous homes and allowing traffic for those homes to use what is essentially a gravel driveway.
Which was what the real concern here was,
Well, from my client's testimony, yes, he was concerned about that.
That already included that it couldn't be done.
He didn't know that. But yes, it is in the document. That was his primary concern. That was the reason he contacted his attorney on the day before the auction occurred. Simply, as a practical matter, as a matter of reality, it was not an issue for him until the sale of the property became a reality. When the Dysarts were using it, I believe there's testimony in the record that the Snyders had no concern with their use of the driveway, that it was respectful, that they drove slowly. That is obviously up in the air as to how future buyers of the property may treat that use. With respect to the parties to the original agreement, the Mops and the Dysarts, with respect to their testimony, it's inconsistent as far as what their intentions were. And on the one hand, they say it was intended to be permanent, yet the document itself does not indicate that it was permanent. On the other hand, there's testimony that it was intended to allow the Dysarts access to the home for as long as they owned the property. On a third example, there's testimony from Mr. Dysart that he believed it was to provide for access to the home as long as the home was on the property. Those inconsistencies in itself were more accurately characterized as assumptions as to what the document did say or was supposed to say, as they are intentions of the parties. The evidence was there was very little, if any, discussion whatsoever between the parties themselves or between the parties and the attorney who prepared the document as to what the manifestation was to be in that document. There was no evidence that the parties explicitly said the circumstances under which it may be revoked. There's no evidence actually that they discussed whether it was revocable, how it was revocable, when it was revocable, or anything of the like. Those are not the situations in which reformation is typically granted. We typically see situations where there is a document that evidences a different understanding that the parties had cumulatively prior to the mistake in the subsequent document. The common example would be a purchase agreement and a deed, where the purchase agreement, for example, says a description of the property that varies from the description in the deed, or where the purchase agreement says the grantor is reserving mineral rights and the deed does not reflect that. You have some evidence of an actual intention of the parties as opposed to just inconsistent testimony about what they thought the document was going to convey.
Well, in many of the cases, though, where one of the parties is deceased, and so they're left with circumstantial evidence as to what the intentions were. Here, not only do we have both of the parties who were present and testified, we also have the attorney who testified, who drafted the document.
That is correct, Your Honor. The attorney's intentions do not appear to be relevant as far as what he intended the document to say. It is the parties to the document's intentions. And if they did not relay intentions to the attorney, and it does not seem from the evidence that they did, then their testimony as to what their intentions were is really significantly less credible at this point in time than had there been any sort of manifestation of that in a written documentation.
Well, the trial court seemed to find the testimony credible.
The trial court did make the determination as far as the intention being to use the word "and" in that. But that itself is somewhat contrary to the party's testimony, because they testified as to the fact that the agreement was to be permanent, or it was to provide access as long as the home is on the property. And that's not what the trial court's reformation, simply changing the word from "or" to "and," actually accomplishes. The trial court's ruling did not give effect to the intentions as expressed in the testimony given at trial. The standard that the appellees had to present at trial was clear and convincing evidence. The inconsistent testimony as far as what the intentions were does not meet that burden. It was potentially a key aspect of the agreement, of any easement, any license, the terms under which it would be revoked, if it could be revoked at all. The failure to address that between the two was an oversight, much more than a mistake. And it was also a negligent oversight, an inexcusable oversight, given the fact that it is such a key element of the agreement itself.
You have just a little less than 5 minutes. Do you want to reserve that?
I will, yes, ma'am. Thank you.
Please the court. My name is David Zakor on behalf of the appellees, David and Catherine Dysart. We would submit that there are really 3 issues before the court here today. The first, as was touched on in the initial argument, is the true nature of the document that was recorded in Official Record Volume 26, page 95. You've heard the appellant's claim that that document was in fact a license, meaning that it allows personal privilege, it's non-assignable, it doesn't convey a property interest, it's revocable at will. We would contend, though, that the document's properly characterized as an easement, conveying property interest, running with the real property into perpetuity to the benefit of the heir successors and assigns, and most importantly, not being unilaterally revocable. A look to the text of the document itself, I think, really supports its proper characterization as an easement. First, as the court's already noted, the document self-identifies as an easement. In the recitals, it specifically states that the grantors have agreed to grant and convey, which points again to a property interest being transferred. Sections 2, 3, 6, and 8 of that document all contain language that conveys rights to the grantees, heirs, successors, and assigns, which again is contrary to the personal nature of licenses. Section 2, again, as the court already pointed out, contains a very specific termination scenario which would require for it to be triggered an act or omission on behalf of both parties. Again, completely superfluous to include such a thing if the entire document is revocable at the will of either party. Within Section 2, again, then, identifies the document as an easement, and the explicit text directly distinguishes that easement from the grant of a mere license. Section 8 contains language that the relevant conveyances run with the land, again, contrary to the personal nature of licenses. As the court noted also, the document was recorded. There would be no need to put a third party on notice of something that isn't a property interest. Basically, the appellant's sole argument hinges on a single conjunction in Section 6 of the relevant document. That section, which we have the uncontroverted testimony of the drafter indicating was inserted as a boilerplate provision to protect the interests of the parties from lien holders, was never intended to apply to any argument for unilateral revocation. So in light of all those factors, the Dysarts would submit the document in Official Record Volume 26, page 95, is in fact an easement. Secondly, turning to, yes?
How did you need information in Section 6 really didn't purport to say what the appellant is saying?
Because in this instance, Your Honor, the fact pattern, there was an auction scheduled to sell the property. And in the days immediately preceding the auction, Mr. Snyder, on behalf of Circle J, made the auctioneer aware that he was purporting an ability to unilaterally terminate.
I understand that, but I'm wondering if we would determine that reformation wasn't proper, would that negate it being an easement?
I don't think potentially in terms of the actual nature of it, but in terms of perhaps providing a title cloud to third-party interested buyers, would have a severe detrimental impact perhaps on the Dysart's ability to sell the land if that's what they chose to do at a future date. And I guess again, in this instance, as the record indicates in the statement of the case, Mr. Snyder, as on behalf of Circle J, did file something on public record with the Wayne County Recorder's Office, basically evidencing his intention that he was terminating the easement. So again, that would provide a title cloud for anybody interested in buying in an auction setting or in a private setting. Second issue goes back to that conjunction in Section 6. And again, Dysarts would clearly state that the use of or as opposed to and was in fact a mutual mistake. As has been noted, there was uncontroverted testimony from both parties to the original easement, as well as the drafting attorney, that the document was always intended to create permanent access to the property owned by the Dysarts from the roadway, the applicable roadway being Pleasant Home Road. All flatly denied any claim that that access would be unilaterally revocable by either party. In fact, as I mentioned previously, the drafting attorney testified that that section was a boilerplate provision to prevent any infringement on the rights of the parties from being basically counter-redeemed by a third-party lien holder. He further testified that the use of or as opposed to the use of and was a drafter's mistake. It was never intended to give rise to any interpretation that the easement could be unilaterally revoked. And he further testified that in discussions with his client and in the client's testimony, discussion between the parties, everyone was on the same page that this was to be an easement that would run with the land and provide that access from Pleasant Home Road to the Dysart's property. With regard then to a third issue, Mr. Snyder and Circle J have claimed that they're bona fide purchasers. But again, in looking at the timeline, it's very important to note the sequence of events. The Dysarts purchased their property in 1996, specifically in June of 1996. On the day of that purchase, they also signed and recorded the easement that's on record, in official record volume 26, page 95. The driveway that covers that easement property has been their sole continuous access to the residents ever since that point in time. The appellants, meanwhile, they purchased the property that's currently held in the name of Circle J in 2008. We've got the uncontroverted testimony of Circle J's predecessor in interest that the appellants, specifically Mr. Snyder, were aware of the presence of the easement through negotiations between that predecessor in interest and Mr. Snyder at the time of purchase. At the time of the purchase, in the time frame that it occurred between 1996 and 2008, additional deeds, evidencing minor land transactions between the Dysarts and that predecessor in interest, had been placed on public record. Those all contain notations that land currently owned by Circle J was subject to the easement recorded in official record volume 26, page 95. Additionally, the appellant's purchase contract directly and explicitly stated that the property looking to be bought was subject to an easement recorded in official record volume 26, page 95. The deed then that actually was placed on record transferring the appellant's current property to Circle J LLC also contained that notation that the property being purchased was subject to official record volume 26, page 95. The testimony of Jamie Snyder, Mr. Snyder admits that he had an attorney representing him through all points of the purchase process, that he had an opportunity to read and review all the relevant documents, and that he had an opportunity to examine all documents that were on public record at the time of his purchase. With all those resources available to him, he admits at trial that he believed at the time of his purchase that official record 26, volume 26, page 95, was in fact an easement, with everything that the term easement conveys. Coincidentally, it took 5 years in the presence of an auction of the Dysart property for Mr. Snyder to become aware that he could make the argument that's being presented to this court here today. And further illustrating the sequence of events that we also have uncontroverted testimony from Catherine Dysart. Such argument was raised by Mr. Snyder after he had already made oral overtures to Mrs. Dysart concerning his prospective purchase of the Dysart property in the days leading up to the auction. In light of all those factors, Mr. Snyder, Circle J, far from an innocent purchaser, and we would submit that he's not a bona fide purchaser, as both actual and constructive notice were provided prior to that purchase in 2008. I guess as an ancillary point then, assuming for the point of argument the court would find that Mr. Snyder was a bona fide purchaser, still no damage has been established. There are two cited concerns that have been raised by the appellant throughout this process. One, traffic concerns, and second, the safety of children. With regard to the traffic concerns, as the court's already noted, there's a provision in the easement at issue that provides that the easement is only to be used for the benefit of the real property that then bears the residence that's currently on the property. So even if that 50-acre parcel was subdivided 50 times, it's still only going to be available for the use of the single owner of the residence that currently stands on the premises. So there's no concern with multiple families using said lane or multiple parcels using that. It's going to be limited to a single property holder. Additionally, with regard to the safety of children argument, as was mentioned at trial, Mr. Snyder testified that no children presently live on the premises, that they have not lived on those premises at any point since he purchased the property, purely speculative in nature. So I guess to encapsulate Appellee's arguments here in this circumstance, we believe the decision of the trial court should be upheld, that official record volume 26, page 95 is in fact an easement, that the use of or as opposed to the use of and in section 6 of that document was a mutual mistake, as testified to by all relevant parties, that appellants are not bona fide purchasers, and that as they had both actual and constructive notice of presence of that easement at the time of purchase. And then finally, that there was no damage being suffered by the appellants with trial court's grant of reformation.
I have a question. I'm
Yes,
not
sir.
sure whether it's probably addressed to you or to your opposing counsel. I was trying to read to see that there was a reference in either the facts or the argument about a land swap.
Yes, Your Honor.
And that was not clear to me.
Sure.
Could you?
Yes, basically what took place in 1996 when the Dysarts originally purchased the property from Mr. Snyder, Circle J's predecessor in interest, they purchased an approximate 50-acre piece. In the timeline between 1996 and Snyder's purchase in 2008, there was two minor land transactions between the Dysarts and the predecessors in interest, basically rearranging a portion of the boundary lines between the two properties.
Did it affect the property in which the easement?
Ever since the Dysart, no, the property that contains the easement over which it runs was not impacted. Basically, like I said, what took place was a flipping of boundary lines on alternate edges of the property. But since 1996, that easement has been continuously used by the Dysarts as the sole access to their residence from Pleasant Home Road. Thank you.
No.
Thank you. To clarify your last question, Your Honor, the home that the Dysarts purchased is on the western edge of the property. The original purchase of property gave them access on the western side to the public road. The swap referenced in the appellee's brief was a swap of property from the western edge to the eastern edge, which means now, instead of having access to the road on the western edge, the access to the road is on the eastern edge. That's why it is, at this point in time, significantly more difficult for them to build a driveway to the home from accessing the public road than it was when this document, when the agreement, the reported easement was created. At that point in time, it was actually quite accessible on the same side of the property that their home currently sits on. With respect to the bona fide purchaser argument, the question really is what the Snyders or Circle J had notice of when they made this purchase. They do not deny that they had notice that the Dysarts were using the driveway. They don't deny that they had notice of the documents that were recorded with the county. Mr. Snyder testified that he was aware of the easements as far as the documents labeled easements, not necessarily easements in the legal sense of the word as opposed to a license. The appellants do deny that they had noticed that the recorded documents contained an error, that error being the one that gave them the right to unilaterally revoke the use. They also deny that they had noticed that the Monks and the Dysarts had intended for the document to say something other than it apparently did. Mr. Snyder testified that he did not know the use of the driveway could be revoked when he purchased the property, but there's no evidence to indicate that he didn't know that it couldn't either. There's a distinction, and I think it's a distinction that's important and a distinction that the appellees ignore. The appellants did not know that they couldn't revoke the use at the time they purchased that property. That's what we're looking for in a bona fide purchaser. The documents themselves, the documents that were provided, the documents that were on record, said grantees or grantors. That is what the Snyders had notice of when they purchased the property. Arguably, because they had an attorney, the attorney's knowledge and understanding would have been imputed to my clients as well. But there was no evidence presented by the appellees that the attorney read the document and understood it to be an easement, understood it to be an interest in the land, understood it to be permanent or to be revocable only upon mutual agreement of the parties. If there had been evidence of such, certainly the argument would be there that my clients were not bona fide purchasers, but they're not. As far as we know, the attorney read that, saw grantees or grantors, and understood it to be unilaterally revocable. That is what he advised the client at the time that Mr. Schneider contacted him prior to the auction. That was the testimony given at trial.
That was also the first time your client even had that within his mind, right?
The first time he did, yes. As far as what his understanding of the document would have been at the time of the purchase, the evidence is essentially he had no understanding of what that particular provision in the document meant.
So whose duty would it have been to find that out when you're purchasing it?
It would be my client's responsibility, certainly, but his agent himself, the person hired to determine what the documents provided, what the easements provided, would have been able to determine that, but there's no evidence as to whether he, in advising my client as to whether to move forward with the sale, as to the value of the property or anything along those lines, had considered the effect of the and or use of the word in the document. I think the appellees would have needed to produce evidence of that to indicate whether or not there was notice and whether or not Circle J or the Snyders would have been bona fide purchasers. Just simply to conclude, the mutual mistake in and of itself prevents reformation in this case. The appellants would request that this court reverse the decision both as to the finding of an easement and to the reformation of the documents. Thank you.
Thank you both for your presentations to the court. The court will take the matter under advisement. A written opinion will be decided and sent to both parties, to all parties, I should say, and on the website of the Supreme Court in the United States.
Thank you.
I hope you have a good rest of your